Right, so welcome back to continuation of our discussion of jurisprudence. So we would like to start with the legal positivism, having concluded discussion of natural law. So just a minute, let me share the screen with you. Yeah, so when we started discussion of jurisprudence, at the very introduction, we made the point that the central issue explored in jurisprudence comes to what is the nature of law? What makes law, and so on? How can you recognize law? Why do people obey law and all that? We said all these things, they can be reduced into two things, what they call the is and the ought question. What is the law? And then what ought the law to be? Or what is law, or what ought law to be? And what ought law to be, as we noted, gives rise to the natural law school. And then what is the law give rise to the legal positivism. So we have what we call like the is question and then the ought question. The ought question is explored mainly by the natural law school. And then the is question is explored mainly by legal positivism. So legal positivism is based on the idea that the validity of law is more grounded in social facts. That is the manner in which norms are made, the form in which norms are presented, then the source, that is from where do we get norms from. So all these are what we call the social facts. And for legal positivism, if you are talking about law, law is nothing more than that which is positive. That is the law which has been laid down or prescribed by one who has the power or the authority to prescribe, promulgate laws, as it were. So long as the law has emanated from that recognized source, that recognized authority, and it has the appearance of how law emanates from that authority, that recognized source, then that suffices. That is the law. Therefore, legal positivism entails a rejection of the metaphysical propositions of the natural law school as not being supported by empirical facts. For example, natural oftentimes is accused of actually indulging in abstractions, things which are not rare, things which are not tangible, things which cannot be reduced into empirical verification. Those are the accusations which natural law actually suffer. And for legal positivism, by and large, they are more interested in empirical facts, empirical dimensions of the law. And for that matter, legal positivism accepts the distinction between what the law is and what the law ought to be. So I've talked about this, the is question and then the ought question. So what the law is. So that is factually, empirically, what the law is. And what the law ought to be. That is the aspirational character. Aspirational character, or the ideal which we would like the law to reflect. That is what the law ought to be. That is the ought question. And legal positivism takes account only of positive law. And by positive law, we are talking about laws made by human beings as opposed to any other law. So for them, if we talk about law, law is that which is positive, that which is made by whoever is given the power to make the law. And for that matter, for the jurists from legal positivism tradition, the proper activity or the proper question which ought to engage the attention of the jurists or the students of philosophy of law or jurisprudence is what the law is. This is the most important question, what the law is, according to the legal positivists, rather than what the law ought to be. And as I told you not long ago, to the natural law school, as we've seen, they too do say that the most important thing which should be discussed is what the law ought to be, rather than what the law is. So we can summarize, or we can try to use the broad brush approach to work out the features of legal positivism. Laws are generally commands of human beings. So let's keep that in mind. And then there is no, so laws being commands of human beings, that is to say that law always, what they call law, always emanate from human origin. So let's keep that in mind. And then two, there is no necessary connection between law and morals. Legal positivists hold the view that morality is entirely a different matter from law, and we shouldn't attempt to see any natural connection or link between law and morality. And of course, you notice that there's a famous Hart-Fuller debate, and what we call the separation thesis, as to whether law is actually immune from all influences of morality and so on. So we come and discuss that at the end of discussion of legal positivism, where natural law represented by Fuller comes face to face with legal positivism represented by H.L. Hart after the Second World War events. Now, the third proposition of legal positivism we need to take note of is that the analysis of legal concepts is worth pursuing and distinct from sociological and historical inquiries and critical evaluation of that. So they say that yes, we are interested. So that is why we even go to the sense of calling legal positivism, they call it the analytical jurisprudence. Yeah, so that is why sometimes we call legal positivists, a good number of them, as the analytical jurists, or that their work is a work in analytical jurisprudence. And you notice that as we take some of the proponents of legal positivism one after the other, they try to go on the tangent of straight analysis. And analysis simply nothing more than breaking things down, right, into their atomistic components. You know, you break things down into their smallest units so that we can see clearly the patterns and also each of the building blocks within the various constructs which we are talking about. So for legal positivists, they emphasize analysis of legal concepts. And for them, analyzing legal concept is not the same as being interested in the working of the law in society or impact of society on the law. That is the concern of sociologists or sociological jurisprudence. And also how the past of society has actually shaped the law that they have and their legal system. So that is the historical jurisprudence.
Sir, please, we have
sorry. What did you say? Did you say something?
Yes, sir. We can hear you well. The line is breaking.
There is the internet. I cannot do anything about it. It's the internet because I'm speaking very loud. And I'm at one place, I'm not moving around. Or it may also be your location. I don't think you are all at the same location, isn't it? Okay, so the fourth proposition of legal positivism is that a legal system is a closed logical system in which correct decisions may be deduced from predetermined legal rules by logical means alone. So you will notice that some of the scholars that we are going to, for example, Kelsen, you've heard about Kelsen, when we're learning constitutional law, his Grunom, if you remember your discussion of the legal effects of constitutions or revolutions on pre-existing constitutional order. I'm sure you came across Kelsen. If you read the case of Salah versus Attorney General, and also ex parte Mabutu, and then Ladna Beck, and ex parte Matova, and then DPP against Michel. If you read those cases, you have encountered Kelsen at a very early stage. But we look at him if you haven't read that. Now, we are saying that legal positivists, they see law as a logical system. Like logic is about, you have premises, and then you have this premise, then this conclusion can be what? Arrive at. That is the kind of thing that legal positivists actually use. Then moral judgments, the legal positivists will say, cannot be established as statements of facts. So moral judgment cannot be established as statements of facts. And for that matter, that should not be part of the law. And that is where they part company with natural law. Natural law, they are not just interested in the law having been laid down, but also the moral quality. Is the law just? Is the law achieving something good and all that? Those are the concerns of natural law. But positivists hold the view that, yes, moral judgments cannot be established as statements of facts. On the other hand, can by rational argument or evidence, you can establish a moral judgments. You cannot use any empirical material to actually establish it or to support it, so that you can say that this is it or that is that. And most of the things about moral judgments are also emanating from some abstractions. Okay, so we will take the contributors to legal positivists one by one. We'll start with Jeremy Bentham. Jeremy Bentham. Jeremy Bentham is said to have been one of the pioneering, and even some even say that he's even like the pioneer of legal positivistic thinking. Bentham was a jurist, economist, and philosopher. And if you look at the literature, he represents what we call the classical school. That is the very early version of legal positivism, at least among English scholars. Now, Bentham's theory is also called the imperative theory of law or command theory of law, based on the premise that law is an expression of political facts in which the key concepts are sovereignty and commands. So for him, if we are talking about law, then we are talking about existence of a sovereign, and that sovereign actually giving orders or commands. So the orders or the commands which the sovereign gives, according to Bentham, is law. So therefore, if you want to talk about law, you must find out, do we have a sovereign? Or do we have something in which sovereignty is vested? And whoever is the sovereign, has he actually given out any orders or rules? If the answer is yes, then what he has done is what we call law. So, so you notice that he is actually reducing law to purely human arrangements, isn't it? The sovereign must be a human being, and that human being has expressed certain wishes or orders or commands, and that should be obeyed by everyone, and that is law for him. Now, Bentham accepts that there is a distinction between what the law is and what the law ought to be, just like all other positivists. Now, Bentham sees appeals to natural law, or what the law ought to be, as nothing more than private opinion in disguise, or the mere opinion of men self-constituted into legislatures. In other words, for Bentham, the so-called talk about natural law regarding what the law ought to be, in his view, comes to nothing more than some individuals or some people trying to express their opinion on the law, rather than letting us take the opinion as what the law ought to be. And that is why he said that we can also see it as the mere opinion of men self-constituted into legislatures. So that is his, if you like, criticism of natural law. That natural law is not rare. Natural law is just a private opinion in disguise. People giving their opinion about the empirical existence of the law. To Bentham, therefore, law ought to have a function or purpose informed by the principle of utility. That is, the pursuit of the greatest happiness of the greatest number. So that is law. And this principle is very important. What we call the principle of utility. It's something you should actually keep in mind. And you also hear about utilitarianism, right? Utilitarianism. So Jeremy Bentham is associated with the ethical approach we call utilitarianism or consequentialism. And he develops this idea by espousing the principle of utility. And by utility, as I indicated, he means the pursuit of the greatest happiness of the greatest number. So that is what he means by utility. That is to say that a thing can be said to be having utility or as being valuable if it gives greatest happiness to greatest number of people. So that in his view, anytime you want to determine whether a situation or a measure is something worthwhile, you must find out, does it advance the principle of utility? In other words, is it going to result in greatest number of people being happier? If the answer is yes, then that is something which has utility and must actually be pursued. And Bentham will say that this same idea should apply to the science of legislation. So if we look at the some of his works, which are extracts are also in the Freeman's jurisprudence, his works like Fragment on Government, and also an introduction to the principles of morals and legislation, which you have in your Lloyd's Introduction to Jurisprudence. If you have my 9th edition, you can go to page 218 and read just an extract from Bentham's work. And Bentham will make the point that, quote, the principle of utility recognizes this suggestion. Sorry. Bentham will say, and let me quote from his work when he explained the principle of utility in his work. Let me quote his own words. Nature has placed mankind under the governance of two sovereign masters. So Bentham speaking, pain and pleasure. It is for them alone to point out what we ought to do, as well as to determine what we shall do. On the one hand, the standard of right and wrong. On the other, the chain of causes and effects are fastened to their throne. They govern us in all we do, and in all we say, in all we think. Every effort we can make to throw off our subjection will serve but to demonstrate and confirm it. In other words, a man may pretend to abjure their empire, but in reality, remain subject to it all the while. So Bentham is saying that whether we like it or not, human beings, we are governed by two things, pain and pleasure. We like to avoid pain as far as possible, and we like to pursue pleasure as far as we can. So that is the point that he is trying to make, and that is the essence of his utility. And for that matter, Bentham will say, and I quote again, the principle of utility recognizes this subjection, that is pain and pleasure, and assumes it for the foundation of that system, the object of which is to rear the fabric of felicity by the hands of reason and of law. Systems which attempt to question it deal in sounds instead of sense, in caprice instead of reason, in darkness instead of light. Yeah, so the utilitarian principle that the pursuit of greatest happiness of the greatest number is actually a deduction from his observation that human beings are under governance of pain and what? And pleasure. So how did Bentham define law then? According to Bentham, law is defined as an assemblage of signs, declarative of evolution, conceived or adopted by the sovereign in a state concerning the conduct to be observed in a certain case by a certain person or class of persons who, in the case in question, are or are supposed to be subject to his power, unquote. So, I mean, all this winding statement comes to the fact that for him, law is expression of, if you like, the wishes or the commands of whoever is the sovereign. So the wishes or the preferences of whoever is the sovereign, given in the form of a command, is law, according to Jeremy Bentham. Then he will explain for us, what does it mean by a sovereign? Who is a sovereign? Whose commands are actually considered law? Well, according to Bentham, a sovereign is any person or assemblage of persons to whose will a whole political community are, no matter on what account, supposed to be in a disposition to pay obedience, and in that preference to the will of any other person. So if you have a political community and there you can identify a person or group of persons, and to that person or those group of persons, all others are disposed to obeying them. In other words, they accept whatever they decree and comply with it, then that is a sovereign. That is a sovereign. And for that matter, the commands or the orders or statements of the wishes of such a sovereign is what he will call law. And that is why, in simple terms, we say that by Bentham, law is the command of the sovereign. That is law. And that is why we say that Bentham's theory is the command or imperative word, theory of law. Command or imperative theory of law. Because he conceived law as a command of the sovereign, being either one person or a body or supreme governor, as it were. And according to Bentham, law is divided into two parts, directive and incitative. So by directive, is referring to the fact that which announces conduct to be done or prohibited, and incitative, that which predicts the sanctions to be applied. Of course, that is somewhat similar to probably what Article 19 of our Constitution. Article 19 of Ghana's Constitution, Clause 11. Article 19, Clause 11 says, and I quote, "No person shall be convicted of a criminal offense unless the offense is defined and penalty for it is prescribed in written law." So that is what Article 19 Clause 11 says, what you call the legality principle. So nothing is a crime unless it is defined in written law and then the sanction prescribed for it. And so if you go back to Bentham's dual approach, that is seeing law as directive and incitative. And by directive, it means that that aspect which announces conduct to be done or prohibited, just as we've seen in Article 19, Clause 11. And then incitative predicts the sanction to be applied. So you notice that the directive and incitative dichotomy within Bentham's jurisprudence is reasonably reflected in Article 19, Clause 11 of the Constitution, when it says that no person shall be convicted of a criminal offense unless the offense is defined and penalty for it is prescribed in what? In a written law. Sanctions within Bentham's legal positivism or his theory is really crucial. So sanctions are an integral part. That is to say that if you are trying to understand Bentham's theory of law and you put sanctions aside, it will not be complete. The picture will be distorted because for him, his understanding of law also goes with sanctions which are out there for disobeying the commands of the sovereign. So to Bentham, the sanction of the law rests upon, quote, the expectation of certain events, the prospect of which it is intended should act as a motive upon those whose conduct is in question, unquote. And that is why, and this one you can go back to his pain and pleasure arrangement. So the sanction will certainly be a certain pain which will be inflicted upon you if you decide to go contrary to what, for example, the law expects of you or something like that. So it is a sanction which creates legal obligations on the party to whom it is applied. Because if you don't do what is prescribed, then you incur the sanction. You suffer the consequence. So the sanction may be coercive or rewarding. It may take one of several forms. It may be moral, religious, or political. That is Bentham's original work. Now, law which imposes no sanctions are not complete laws, but merely part of laws. So, to have a full-blown law, the law must have accompanying sanction. And if there's no accompanying sanction, then according to Bentham, that is not law, but a complete law, but just a mere, if you like, on the periphery, just an aspect of what we call law. According to Bentham, law also has a purpose or function, which is determined by the principle of utility. So, I mean, you say that, well, is Bentham a natural law scholar? Because natural law scholars, they see law as being teleological, as having a purpose. Well, Bentham is not really a natural law scholar, despite the fact that some of his claims come close to some of the arguments of natural law school. Now, it is the essence of the principle of utility that man's actions are governed by two sovereign masters, as we noted earlier on, pain and pleasure. These are the two sovereign masters which actually dictate our actions. And this pain and pleasure thing, I think by and large, is true for everyone. You just examine your own actions and see whether you don't see that driving motivation as whether to avoid a certain kind of pain or to accomplish a certain kind of pleasure, as it were. Utility, according to Bentham, is defined as that property in any object whereby it tends to produce benefit, advantage, pleasure, good, or happiness. Alternatively, prevent the happening of mischief, pain, evil, or unhappiness to the party whose interest is considered. This could be individual or community. So this is what he means by the utility. So pleasure in this sense is to be equated with good, and pain is to be equated with evil. So pleasure goes with good, pain goes with evil. So a thing is said to have utility in Bentham's reasoning when it adds to the sum total of the pleasure of the individual considered, or diminishes the sum total of his pains. So look at it, whether it adds to the aggregate of pleasure the individual is receiving, or it diminishes the aggregate of pain which the individual has to endure. Now, the sources from which pleasure and pain flow could be physical, political, moral, and religious. Now, Bentham uses the concept of hedonistic or philosophic calculus. It's sort of like a mouthful, isn't it? Hedonistic or philosophic calculus to identify the common good of society. That is the greatest happiness of the greatest number, which is the aim of any legislation. So for Bentham, any legislation must satisfy this principle, the principle of utility, which is reduced to the hedonistic or philosophic calculus. That is to say that is the law giving greatest happiness to the greatest number of people? Is it doing that? If it's doing that, then that is good law. That is a law. And according to Bentham, it is possible to make a quantitative comparison of pleasure and pain. So he devised some sort of like a formula, although not with any mathematical and scientific accuracy, which one can use to work out the pleasure and pain in any particular situation, so that you can arrive at whether you are getting greatest happiness of the greatest number or vice versa. Now, this quantitative comparison of pleasure and pain, according to Bentham, involve taking an account of each distinguishable pleasure and pain produced in a person by a given act. So these will be summed up to arrive at the good or the bad tendency of an act. So individual happiness will then be subsumed into a social total And the resulting social total will then be identified with the common good of the society. So that is to say that you work out the individual happiness, but that has relationship with the, if you like, happiness of the entire society. And for that matter, if something would give happiness to the entire society, it is considered as having taken care of that of the individual. And for that matter, that should supersede any other individual choices, as it were. To Bentham, therefore, the science of legislation consists of knowledge of the good, while the art of legislation is the discovery of the means to realize the good. So making law for him, as it were, is like a science, and it has two facets. That the science itself is you knowing what is good, and then the art of the legislation, you trying to discover the means to realize that good. For that matter, the foundation of a legislator's reasoning must be the principle of utility, which is aimed towards realizing the common good. These acts, which the legislature seeks to prevent, must be an evil far greater than the law, which prevents them, thereby increasing the sum total of happiness of the community. So if we look at it, sometimes when we are making a law, internet. Yeah, so if you look at what happens in our legal system, we talk about the law trying to cure the mischief. And I think that in some respects, it comes close to what Bentham is saying, that the legislators must actually be governed by the principle of utility. And that is to say that he must aim at realizing the common good and seek to prevent evil. That is evil far greater than the law, which prevents them, thereby increasing the sum total of happiness. So we have what we call like the mischief. So if you look at Article 106 of the Constitution, for example, right? Article 106 of Ghana's Constitution. If you go to Article 106, Clause 2, Paragraph A, and I quote, "No bill other than such a bill as is referred to in Paragraph A of Article 108 of this Constitution shall be introduced in Parliament unless A, it is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects of the existing law, the remedies proposed to deal with those defects, and the necessity for its introduction." So if you look at Article 106, 2A, if you are going to pass a law, the accompanying memorandum should tell us what the defects are. So what is the mischief? So what is the evil, the greater evil which exists now, which the new law is trying to what? Cure, it's trying to overcome. So it's similar to what Bentham is telling us. Okay, so any question about Bentham before we move on? Any question about Bentham before we move on with the company law? Okay, then we are going to change over to company law. So use the same link to come in again. All right, thank you.